Miss Mary?
Yes.
Hi, Judge. Did you get the email that I've been waiting for 4 hours? She said she was here waiting. Just now.
Yeah, just now.
Yeah, we need a rule, a law, or something.
Who waived?
Violet wave Felicity.
Again, good call.
Oh, I've been communicating with her since 9 o'clock this morning.
I know, it's so
So
frustrating.
that takes time.
She just signed it herself. She didn't sign as attorney, in fact. Did she talk to her, do you know? Felicity went yesterday and it was ordered for placement.
Okay, we'll do it
Okay.
because it's not valid waiver.
Okay.
Thank you. I meant to go ask Judge Terry what she did yesterday.
Right?
Yeah. I'll see you in a few minutes.
All right. So, Felicity,
Did she have one here today?
she just waived.
Okay.
Oh, so
No, she's gotta have a hearing.
She does need one?
She does need a hearing. The waiver's not,
it's not-
no,
No,
it's not valid. Yeah,
Oh.
we do
Yeah,
need a
Sorry,
hearing.
you are gonna. I'll see you, sorry.
No,
It'll
you're
be
good.
30 seconds.
I'm gonna email her back for her. Oh my gosh.
Good afternoon.
Can't breathe in this.
You're hearing.
William's like, make sure you have your mask on. I'm like, just pour some, I don't have to. Yeah, hello.
I don't know who
I am
does that.
not a mass police.
I know, I keep getting in trouble back there.
Mary, do you mind if I sit here?
No, go ahead. I'm tired of getting in trouble.
Mr. Medlin and Mr. Lewis, don't get on T, it's not my call.
This is Larry too. What you doing?
Like I would
And I've been at out in the heat.
So I figured.
You been out there?
Like when I put it up.
They dismiss. Whatever works. He's here.
Oh, yeah.
That's.
I'm sorry?
Peter.
You okay? You're coughing that proper.
Yes.
Coverage too. Wasn't sure if he was gonna be the.
I assume she's.
We're not gonna start until right at 1:30. And I want to get, you go ahead, but I want to go ahead and get, check this out.
Good afternoon, everyone. These are the detention hearings for the 323rd Judicial District Court of the State of Texas, Tarrant County's assigned juvenile court. The purpose of today's hearings is twofold. First, to determine whether the children who've been brought into detention, whether or not probable cause exists to believe that the children may have engaged in delinquent conduct. This is not a trial. This is not a determination of whether or not the child actually did what he or she has been accused of doing. Instead, it's merely whether or not probable cause exists to believe that the child may have engaged in delinquent conduct. The court is allowed by law to make that determination using hearsay evidence. And that will be provided to the court through the form of police reports that have been forwarded to the Juvenile Probation Department that will be then given to me. If the court finds that probable cause exists to believe that the child may have engaged in delinquent conduct, the court will proceed to a second determination of whether or not the child should remain in detention or be released to a parent or guardian. In making that decision, the Texas legislature has outlined 5 factors that the court is to consider, and the court will consider those 5 statutory factors in making that secondary determination should it need to be made. Each of the kids today, you have the right to remain silent and not say anything at all during this hearing. Anything you say cannot be used against you at an adjudication, modification, or disposition hearing. Nevertheless, we have 2 representatives from the district attorney's office here taking notes. So anything you say, even if you think it might be innocent, might nonetheless lead them to information that they might be able to use against you at a hearing. Rather than just blurt something out, whisper it with your attorney today. And that way, he or she can advise you on whether or not you really should say it. Does that make sense? Each of you, I will appoint an attorney to represent each of you. First on today's docket is Serena Byerly. Ms. Byerly, the court has previously found probable cause exists to believe that you engaged in delinquent conduct sufficient to warrant your initial detention. I'm personally familiar with your case. I will note that you've been level 1-0 for the last 2 days. However, given your history of referrals to the department, I'm going to order that you be detained. I fear that if I were to release you today, you would be a danger to yourself. And so, at that basis, I will order you to continue to be detained. Thank you, ma'am. Everardo Macias. Yes, ma'am. All right. Mr. Macias, the court has previously found a probable cause exists to believe that you have engaged in delinquent conduct sufficient to warrant your initial detention. I will note that you've been level 1-0 since yesterday, but the last time you were here in the detention hearing, I told you if you would just remain level 1-0 for a few more days, you'd get released. Didn't quite. So, Ms. Jacobson, what are your thoughts?
He requests, Your Honor, that he be released today. His mother is here and is willing to take him.
Yes, where's the mom?
She's back here.
Oh, okay, okay. Mom, I need him to prove to me first that he can maintain level 1-0 before I can consider his release. He was so close last time.
Can I translate that?
Sí.
Dice que estaba muy cerca a dejarlo salir la última vez, pero quería que estara en el nivel 1, pero por varios días y apenas está en el nivel 1, pero apenas ayer. Sí.
How many days last time did I say you had to maintain level 1-0? Right. Oh, it's still at 8. I'm mistaken. All right. Is he awaiting evaluation?
He does have a psych evaluation scheduled for this Sunday.
Okay. I'll authorize your release after your evaluation on Sunday, but only if between now and then, solid 1-0. Don't get down to 1-0. Solid 1-0.
Yes, sir.
All right, do that, I'll let you go, okay? However, you have to promise to come back when you go to court, okay? Mom, will you bring him back to court?
¿Puede traerlo a su audiencia?
Okay, so on Sunday, if he is still one outstanding, you may pick him up.
Si sigue el nivel 1, puede levantarlo el domingo.
Okay. ¿Tienes preguntas?
No.
Okay. It's up to you, sir. Thank you. Yes.
He wants to be part of this.
Yes. Yes.
Oh, okay.
All right, Mr. Rojas. Mr. Rojas, the court has previously found that probable cause exists to believe that you've engaged in delinquent conduct sufficient to warrant your initial detention. I will not go into the facts underlying why you've been brought into detention. I believe Judge Gibbons covered those thoroughly with you in the past. You have a hearing coming up before him on August 17th, 2021. That is a very, very important hearing. You want to put your attorney in the best possible situation to argue for the best possible outcome at that hearing, because that hearing will make a world of difference on how this case proceeds. The best way you can do that is to keep maintaining level 1-0. I will note you've been level 1-0 for more than a month, and that is very difficult to do. I congratulate you on that. However, given the gravity of the underlying offense, I don't feel comfortable releasing you, all right? But you need to maintain your level 1-0 for Judge Kim, because it is going to make an impact on what he does. Does that make sense? All right, that'll be the report. Thank you, sir. So, yeah. Yes, ma'am. All right, Ms. Willingham, the court has previously found that probable cause exists to believe that you've engaged in delinquent conduct sufficient to warrant your initial detention. I'll note you had a hearing before Judge Terry yesterday. It's my understanding that she ordered you replacement. If I were to let you go today, you would break that quarantine and that would delay you getting to the replacement. So I don't want to do anything that delays you. So I'm going to order that you be detained today, all right? Thank you. Felicity, thank you for being on it. I know that's not easy for you, so thank you. That's a good job. All right, Alejandro. Yes, ma'am. How are you, John? Better than I deserved. All right, John, what brings Alejandro back to court? I thought that after Judge Terry saw him back in March, he was going to be back. What happened?
Yes, sir. He was referred to the department on yesterday. For the alleged offense of a real vehicle. According to dispatch, they noticed that the department, they can contact with the complaint. The owner of the vehicle stated that earlier that day, he lost his keys in the parking lot of the apartment complex up to the court, and then eventually ended up making contact with the individual that's right here and another individual actually in this vehicle.
Alejandro was allegedly in the vehicle at the time? Okay.
He stated to police that he requested his and initially, Alejandro refused to return his keys. And then after he told her that he planned on calling 911, then he relinquished his keys to stay home. He's currently being supervised right now on assault individual family violence. As of recent, we have had multiple non-compliance issues. This officer was just with him 48 hours ago for a home visit, where his mom has indicated that he was not missing. He leaves without permission, and when he does return, he is very professional to her as well. I attempted to encourage him to maintain his supervision. He was actually even placed on curfew checks, nightly curfew checks, which he is still not adhering to. That mom ended up contacting me yesterday, letting me know that he is continuing to leave the house after midnight and does not return until 5 a.m.
Oh. Okie dokie. Well, we're gonna find the problem. Yes, ma'am.
Your Honor, yes, he would be released on an ankle monitor, and then that way he would be where he's supposed to be at all times.
Well, first I'm gonna find the probable cause exists to believe that you've engaged in delinquent conduct sufficient to warrant your initial detention. Second, we got some problems. I don't know if it's you disrespecting women or what, but not gonna put it with that, okay? Your mom has been there for you. You need to start being there for her, all right? This belligerent attitude to mom, not gonna cut it. Not gonna cut it, all right? I'm gonna order you to be detained. We'll see how your behavior levels do in the back. You gotta get to 1-0, you gotta hold it. I'm not gonna tell you for how long, but you're gonna have to hold it before I'll consider your release. I want you to prove to me that you can follow the rules, that you can be respected. Once you prove that to me, then we'll have a talk with mom and we'll see if you've earned the right to prove it to her too. All right, but you gotta earn it from this point on forward. All right, that'll be the order of the court. Right, that concludes today's detention hearings. I thank everybody who's been watching on YouTube. The court has been broadcasting these hearings live on YouTube, keeping with the spirit of the oath of court's provision of the Texas Constitution. However, rebroadcasting or recording all part of these hearings is expressly forbidden in violation of the court's order. May subject you to civil and/or criminal contempt proceedings. If you enjoyed today, please subscribe, like, and rate.